We will dive into why the purchase of 98,000 Elk Horn Coal certificates may not have been exactly legal or ethical. And we will follow how this deal was able to take place after the death of Clarence W. Watson. Would the use of a third party to obtain these stock certificates be legal or a scam? Come along with us as the Kootnes brothers try to take over the Elk Horn Coal Corporation by way of a majority stock hostile takeover. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. Hidden buyers. Part of the deal that Arthur B. Kootnes and Patrick D. Kootnes was able to negotiate when Clarence Watson passed away was the purchase of 60,000 Elk Horn Coal certificates. This was to secure the debts that was incurred by Watson during his time over Elk Horn Coal. On December 6, 1941, the Circuit Court of Kanawha County ordered that it authorized and directed the sale of the 60,000 certificates by the primary receivers. For 2 weeks, the Charleston Gazette advertised the sale of said stock. On December 20th, 1941, it was announced that W. W. Goldsmith failed to keep an arrangement concerning the shares with H. D. Kinsley. These shares were to be sold at a price of $7,500. Kinsley was not present at the court, but was represented by a local attorney. It turns out that Kinsley was married to the Kootnes' niece. It did not take Goldsmith long before he knew that the purchase of the stock was actually being made by Kinsley's attorney on behalf of Arthur B. Kootnes and Patrick D. Kootnes. Howard N. Evenson was made aware of the attempted purchase of the stock through the third party by the Kootnes shortly after the sale was made and before the confirmation of the sale was completed. The receivers did report the sale of the certificates to Kinsley, but failed to disclose that the Kootnes were actually the purchasers. Watson Estate. But this was not the only stock that the Kootnes brothers would end up purchasing and or otherwise acquiring. The remaining 38,000 certificates were purchased by the Kootnes after the death of Clarence Watson. Watson's personal estate representative stated that Watson's finances were insolvent. The 38,000 certificates were part of the 40,000 certificates that was in the June 10, 1937 contract that Watson had negotiated for himself. This is how the sale of the Watson certificates took place. After the death of Clarence Watson, a domiciliary administrator, or the chief administrator of the estate, was appointed in the state of West Virginia. There was also an ancillary administrator, or person who is to oversee the distribution or part of the decedent's estate in which the person was not domiciled, appointed for Hamilton County, Ohio. In these cases, Kinsley would once again step in for the Kootnes. The ancillary administrator had various large claims leveled against the estate, of which the total amount came to $163,663. These claims were purchased by the receivers of Elk Horn Coal Corporation for $850. With this purchase, Elk Horn Coal was now the sole creditor of the Watson estate in the state of Ohio. On May 17, 1944, H. D. Kinsley once again stepped in for his uncles-in-law as he purchased various securities belonging to the Watson, Ohio estate for $22,500.50, plus a fee for collection of $25.32 in a private estate sale. Included in the sale of the securities was the 28,000 certificates of the Elk Horn Coal Corporation. After taking into account the resale of all the securities, the Koonses walked away with the resale of the certificates for the amount of $5,508.50. The domiciliary administrator also had a large claim leveled against the estate, of which the total amount came to $140,000. The receivers also purchased these claims for $700. With this purchase, Elk Horn Coal now owned 40% of the Watson, West Virginia estate claim. The $140,000 in claims were part of the $163,663 in claims against the Ohio estate. On May 22, 1944, the domiciliary administrator held a private sale in which 10,000 certificates were sold to Frank Shaver for $2,000. It turns out that Shaver was the bookkeeper for the Koonses. He would later admit that he purchased the certificates on their behalf. Arthur Koons had the power of attorney and the assignment to transfer the said certificates to a bank. So, on paper, according to the records of the voting trustees, the owner of the 60,000 certificates and the 28,000 certificates is H.D. Kinsley. The owner of the 10,000 certificates is the estate of Clarence W. Watson. All of these certificates would later be impounded by the court. Thoughts? We can see why there would be a huge concern of the hostile takeover of the company through the acquisition of the majority of the stocks. This practice still goes on today in the business and stock trading world. And the actions of the Koonses to acquire the said certificates would definitely raise eyebrows. But it is also worthy to note that at that time, having the majority of the stock certificates did not give either Koons brother voting rights according to the voting trust agreement. Also, according to the balance sheet of the Elk Horn Coal Corporation as of March 31st, 1944, December 31st, 1944, and December 31st, 1945, the stock was only worth $5 a share. Some of the litigants of this case asserted that the stock was really valued at $12 a share. But according to the records, this claim could not be verified. We can also understand why the legitimacy of the purchase of the stocks would be called into question. After all, the Koons brothers did not obtain the stock certificates directly, but through two third-party transactions. And perhaps for that very reason, the court impounded all of the stock certificates in question. In next week's video, we will go over the disagreements between the voting stockholders and the question of whether or not receivership was harmful to the company. Thank you. Kentucky Tennessee Living would like to thank you for watching our video series on the scandals of the Consolidation Coal Company. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.